All right, when you all are ready, let me know. I can go back on the record. I reviewed it. I have some modifications.
Whenever you're ready.
Let's go on the record, Gabriella. All right, back on the record. Now, Elise, I'm going to ask you to enter this as court exhibit, whatever number it is, the first draft of the jury instructions.
Court exhibit is going to be court exhibit 2.
And you also mark this as court exhibit 3, which I have it back. It's the second draft of the jury instructions, so that's going to be number 3. And then you also mark this as court exhibit 4. This is defense's proposed jury instruction. I don't think it'll be an issue, but I want to mark that this is court exhibit 5. That's the United States proposal. All right, go to page 8 of my second draft of the jury instructions. I just want to make sure you all have taken a look at it. I'm concerned with that big paragraph that has language in the negative. So if both sides have reviewed it, I've reviewed it. I don't think there's any typos or any grammar issues.
I mean, it is off of the standard.
It is.
Wording.
I added burglary and or false imprisonment. That language is in there. Towards the end of the paragraph, it talks about retreating, being futile. Before that, it talks about herself and or others and it would have increased her own danger to retreat. So I just want to make sure that wording is acceptable to the parties.
Yes, sir.
All right, let's move on to.
Yes, Your Honor.
And Mr. Altala, I'm going to leave the placement of the burglary and false imprisonment definitions where they are, only because we have the wording of false imprisonment and burglary after that big paragraph.
I believe that's what I was
Oh,
suggesting, Your
all right.
Honor. It was Mr. Tomas's draft that was added a little farther down.
Okay. Burglary, my definition doesn't include the intent to commit a crime therein. I'm going to add in false imprisonment, which is what Mr. Tomas has.
Yes.
So let's move down to the definition of false imprisonment, to the definition of secretly, where I have victim in parentheses. Mr. Tomas, you have the defendant, right?
Yes.
Should it also have the minor children?
Yes.
So it should have defendant or minor children.
Yes.
Can it have defendant or minor child or minor children?
It can, or defendant or another, but defendant or minor children is fine.
Your Honor, having minor children might be prejudicial. It should be another, the defendant or another.
Yeah, but who was in the house that she says she's afraid for? The kids, right?
They're already having an instruction at the very next sentence on confinement of a child under the age of 13. It's already addressing that, so it should just be the confinement of the defendant or another.
Over your objection, I'm gonna have minor child or minor children.
Good.
And wherever you have the word Daisy Link, I just have defendant, just to keep it uniform, because that's what I have in other parts of the jury.
That's fine.
Okay. If there's no other suggestions, I'm gonna move on to the other parts of the jury instructions.
I have no other suggestions for this portion.
All right, let's go to page 1. The cover sheet is standard. Page 2 is the statement of the charge. There's a typo there, crimes versus crime, I'll change that. introduction to homicide, justifiable homicide, excusable homicide, those are also standard instructions. Yes, no, on page 3, just review it to make sure you don't have these other suggestions. All right, we can move on to page 4.
Page 4 of the city has a proposal.
Okay,
On line 2, where it says death is caused by a criminal act of, I believe it should say David instead of defendant.
I'm just gonna keep it wide. I'm just gonna keep wherever it says Daisy Lee is now a defendant.
Well, we've already substituted victim for Pedro Jimenez, it should be defendant substituted for Daisy.
Remember at the statement of the case on page 2, Daisy linked the defendant's case. So they know from page 2 on, everywhere that it says defendant, it's Daisy Lee.
Understood, just making my suggestion.
All right, let's move on to page 5, lesser included crime. Couple typos there. There's a couple E's where they should be she's, the crime should be crime, singular, and
Does it need to say the main crime since it's just one?
yes.
Okay.
So I'm gonna change that. This is another suggestion, I'm gonna move on to page 6, the definition of manslaughter. Okay, we'll move on to page 7, aggravation of second-degree murder or manslaughter by carrying and using a firearm. Should it be used instead of carried?
Be carried in more use.
I agree it should be both.
Mr. Tomas, all being carried or used?
That's fine.
I'll move on to page 8, you already went over?
Page 7, should we, I know it's giving a definition for the term firearm, but should those be in parentheses like that?
That's how the standard instruction is. I can remove it if you want.
Yeah, normally in the past I've removed that, you know.
Which part, starter gun or the,
Well, no, not the entire sentence, just the parental, like brackets.
Okay.
So,
I'll remove those. The brackets, all 4 of them. Page 11, parental rights. As well as the use of transcripts of recordings.
regarding this page, Your Honor, the state did submit, motion for Your Honor to take judicial notice. The state has done a diligent search trying to see if there were any type of court records of an injunction for protection from domestic violence or written pre-trial supervision order of no contact against that person. Looking at the clerk's website, there was no case active between Pedro Jimenez and Daisy Lee. filed. So the state is requesting the court to take judicial notice of those lack of documents and that it does not exist. Similarly to the parental rights instruction.
That's not appropriate. First of all, there wouldn't be any notice because those records are not public. As the dependency case was not public, there's an order which addresses the custody status, and that is the most recent order. That is in evidence.
Your Honor, injunction violations are public, and actual life arrest forms where there are pretrial services conditions are public as well too, if there is a case against the two.
Aren't the pleadings closed? Whatever's in evidence is in evidence. Whatever I've taken judicial notice of, I've taken judicial notice of, right?
Your Honor, we haven't read to the jury at any point in time this judicial notice regarding parental rights, we did suggest it at the beginning. And we are introducing the actual court transcript as well too, to the jury when they come back into it.
Well, there's a document from the dependency court limiting Mr. Jimenez's visitation of the children, right?
Yes.
Okay, and I already took judicial notice that there's no records in my immediate account terminating the parental rights, right?
Yes, Your Honor.
So that's my point. At this stage, you want me to take judicial notice of other court actions,
That's correct.
so the pleadings are closed. Why should I do it at this stage?
Well, Your Honor, because it is essential for the actual justifiable use of deadly force jury instruction that's here. And if you go specifically to page, just one moment to pull it up. We go to page 9 and 10. It talks about the presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom defensive force is used has the right to be in, or the lawful resident of the residence, such as an owner of lease or title holder, and meaning you have to have both of these exceptions. There is not an injunction for protection from domestic violence or written pretrial supervision, order of no contact. Without that instruction here, Your Honor, and since those documents don't exist, the jury should be able to rely on Your Honor's judicial notice saying that that does not exist here to see that presumption of reasonable fear of imminent death does not apply here in this case.
So you're going on page 10, right?
Yes, I say 9 and 10 because it starts before where the rule is created and it's the exception.
So it's A, B, C, or D.
That's correct.
Okay. Are you planning on arguing that there's nothing in evidence regarding the injunction of protection from domestic violence?
I wasn't going to talk about that at all.
Okay. I'm having a hard time because the pleadings are closed. You want me to take judicial notice, essentially of a piece of evidence that no one has brought up until now. And the only issue that came up during trial was the limited supervision of the victim. And there's actually a piece of evidence, including testimony that corroborates that. So that's the issue I'm having now at this juncture. Plus A, B, C, D, there's an or between every single paragraph.
Well, then if it's not being argued by defense, then would there be a stipulation then to remove that portion regarding the presumption of fear?
Absolutely not. Or
Okay.
should I?
Let me give you an example. Vehicle is also discussed in the standard jury instructions. There's no evidence that there's any forcible entry of a vehicle, right? So there's language in here that's extra. It's just for the consideration of the jury.
The jury should be able to consider this as well too, Your Honor. That's just a state's position.
Over your objection, I'm not going to take judicial notice at this stage of the proceedings. What about the language regarding parental rights for the piece of document that's already in evidence?
Your Honor, the state agrees with that.
All right, defense.
Which part are we talking about?
Page 11.
No,
that's one.
Okay, and what about the use of transcripts of recordings?
Your Honor, I do believe you should insert Rule 2.2 here, which is instructions on edited recordings before the use of transcriptions and recordings.
Yeah, 2.2. Just reminding them that they listened to something that was edited.
Yes, Your Honor.
All right, what about use of transcripts and recordings?
That's appropriate.
Defense.
Fine.
I'm going to let them know that there is an item that is in evidence regarding the transcripts. All right, page 12.
It's like the standards.
It is a standard. All right, page 13. All right, tell me 6, 7, 8, 9, and 10, which ones you all want? 6.
Yes, Your Honor. 6 should be included.
Defense.
I'm not sure what has been introduced during this trial to justify this instruction.
Can you think of anything?
Your Honor, so, PJ did testify, during his testimony that he said he's here to get his mom out. And then he was asked, do you know where your mom is? And it was suggested jail. That is the other benefit here in order to get the witness to testify, and that did come out through his testimony.
You can still argue that without arguing.
But it should be something to rule it. Without the instruction, that's not something that the court can consider. And that's routinely said in closing arguments. Everything that's in this
I'm gonna
package.
leave 6N, but you can argue credibility, what he said, what he didn't say, and other things surrounding his testimony. I'll just leave 6N over the defense objection. 7, pressure or threat. Now this is where the PJ argument comes in. All right, there's no objection, I'm gonna leave 7N. 8, there was some attempts at impeachment, I'll leave 8N. 9, there's no evidence of convictions of felonies or misdemeanors.
Agreed, we should take that.
10, there's no evidence of any general reputation evidence.
Agreed.
15 is a blank page, I'll change that. Page 16, defendant statements.
That's the standard.
It's the standard. All right, rules for deliberation, that's also standard on page 17. Page 18, cautionary instruction, which is the standard. 19 is also the standard. Closing argument is standard, submitting case to the jury is standard.
Judge, just a suggestion, on page 19, the last paragraph, should it say the crime charge, since there's really only one?
To the crime charge.
Yeah.
Instead of each crime charge, to the crime charge.
Yes.
Okay, I'll change that. Okay, I'll be back. Just give me a few minutes. The set will bring me down the revised third draft. Thanks.
And Your Honor, I don't know if you want page 22 on a separate page.
I can figure out how to make it go up. I'll see that. All right, folks, I'll be back.
All right. It's acceptable to you all. I did have to set fire off 9 copies to the jury, at least. This is all going to be a court exhibit, is number 3.
I apologize, I'm still going through the page.
I'm sorry, whatever court exhibit needs to be.
6.
back these court exhibits. At least I did in that case.
Do you mind looking some stuff around?
Your Honor, this might be minute, but on page 9, just for reading it, after it says confinement of a child at sentence, it jumps into deciding whether the defendant is justified. I mean, visually, I would think that there needs to be an extra space. You can kind of look at a continuation of the false imprisonment. I don't want there to be any confusion, but
Defense on page 9, so we'll request an extra space.
I mean, an extra space, or just start that at the next page, and find.
yeah, either or.
All right, I'll do an extra space. Is that all?
I'm almost done, but that was it on that page. I reviewed it. I have no other issues, and as well with the verdict form.
All right, defense.
No issues, Judge. I don't have the verdict form.
I emailed it last night.
Oh,
There's one little typo. I'm gonna do it in 2 pages. You can have mine. Sorry about that. Okay, I'll make those changes. I'll come back with probably 15 copies. And feel free to call Chambers if you all see anything else you want me to change. I'll be back.
All right.